Article 326 clearly and explicitly mentions that only those who are citizens of India can be registered into electoral rolls for the purpose of election in India. Unfortunately, in India, no official citizenship card was established till now. Then, consequently, even without any citizenship authentic card, anyone included, including the migrants from illegal migrants from Bangladesh and Burma and other neighboring countries, they faked some document, forged some documents, and got themselves registered into Indian electoral rolls. Since Indian state was very weak state in terms of administrative regulations, and that's why millions and millions of illegal people kept on getting included into the voter list of India. Now, when a proper administrative process, due diligence is being followed, then some people like this man called Yogendra Yadav is trying to bring his anarchical mindset forward and to apply to this process of SIR, and trying to say that the people who have been included into electoral rolls previously, they must be continued to be included, which implies that if an administrative failure has happened in past, then it must be continued in present and future also. This logic ultimately takes us to conclusion that if the crimes and the mistakes in past somehow couldn't be addressed, then they should become ratio decidendi, then they should become precedent, they should become judicial and legal precedent to guide the present and future administrative actions also. मतलब अगर पास्ट में डकैती होती रही है, इसलिए डकैती एक पुण्य का काम है. दिस इज द लॉजिक दैट मिस्टर योगेंद्र यादव इज ट्राइंग टू एनफोर्स एंड इम्पोज. जो गलती पास्ट में इसलिए हुई कि एडमिनिस्ट्रेटिव मशीनरी वीक रही होगी, या जो भी रीज़न रहा होगा, फ्रॉड लीडर्स रहे होंगे, एंटी नेशनल लीडर्स रहे होंगे, इसकी वजह से इलीगल लोग रजिस्टर हो जाते थे, उनको बाहर निकाल के फेंक दिया. इसमें क्या दिक्कत है? सेक्शन 21 of RPA 1950 clearly mentions that SIR must be done before each election, and the purpose of SIR is to remove the names of the people who are permanently shifted or have deceased or duplicate. It is clearly mentioned under section 21 RPA. So 326 article of Constitution and RPA, Representation of People Act, have substantive constitutional and legal basis to conduct SIR exactly in the manner in which it has been upheld, and these two provisions have been used by Supreme Court in upholding the constitutionality of SIR. The fact is that administrative weakness was made superior to constitutional provision in past. मतलब एडमिनिस्ट्रेशन में अगर गड़बड़ी है तो वो गड़बड़ी कॉन्स्टिट्यूशन बन गया. दैट वाज द सिस्टम इन लास्ट 50-70 ईयर्स. तब वो ये कहना चाहते हैं कि बांग्लादेश के लोग पिछले 15 साल में अगर इंडियन वोटर लिस्ट में अगर रजिस्टर हो गए तो फ्यूचर में भी हो जाने चाहिए. क्यों? उनको बाहर नहीं निकाल सकते. पास्ट में गड़बड़ी हो गई, बट प्रेजेंट में तो निकाल सकते हैं. यस, तो उनको निकाल के फेंक दिया गया है, एंड इट इज़ प्योरली कॉन्स्टिट्यूशनल अंडर आर्टिकल 326 जाकर के खोल के गूगल में पढ़ लो क्या लिखा है. ओनली दोज हु आर सिटीजन ऑफ इंडिया, ओनली दोज हु आर सिटीजन ऑफ इंडिया, ओनली दोज हु आर सिटीजन ऑफ इंडिया, ओनली दे कैन बी रजिस्टर्ड, ये लिखा है. सेक्शन 21 पढ़ लो.